Ready? Start. An agreement for sale was executed by the petitioners in favor of respondents on 23/9/1979. Stop. When the same was not honored, original suit number 283 of 1980 for specific performance of the agreement was filed by the respondents. Stop. The suit was dismissed by the trial court on 9/2/1982, against which civil appeal number 269 of 1982 was filed by the plaintiff, which was allowed on 5/3/1999, and the suit was decreed. Stop. The defendants filed second appeal before this court, which was dismissed on 24/3/1999. Stop. Thereafter, a special leave petition number 8127 of 1999 was filed by the defendants before Hon'ble Supreme Court, which, after its conversion into civil appeal, was dismissed on 9/12/2004. Stop. Controversy between the parties arose thereafter in relation to execution of the decree. Stop. Whereas the decree holder filed execution case number 5 of 2005 on 16/2/2005 and an application 10C requesting the executing court to pass tender of rupees 95,000 and permit him to present draft of proposed sale deed, an application 3C was filed by the judgment-debtor under section 28 of Specific Relief Act, praying that the contract stands rescinded on account of default committed by the decree holder to obey the directions issued by the first appellate court regarding deposit of balance money in the 1 month. Stop. Application 3C was rejected and application 10C was allowed. Stop. 2 revisions preferred by the petitioners against both the orders met the fate of dismissal. Stop. Learned counsel for the petitioners submits that once there was an obligation cast upon the plaintiff to honor the decree which attained finality up to the Hon'ble Supreme Court in his favor, but he failed to discharge the same and did not deposit the balance money as required under the first appellate court's judgment and order, the contract stood rescinded in view of section 28 of the Act, 1963, and therefore, both the orders impugned are liable to be set aside. Stop. It is further submitted that question of readiness and willingness of a plaintiff continues to survive under test till the decree is finally executed, and, in the present case, the conduct of the plaintiff was sufficient to disentitle him from getting the decree executed, in as much as once the appellate court passed the decree in the year 1999, the decree holder did not file any execution application till 2005, and it was filed 2 months after the Hon'ble Supreme Court dismissed the civil appeal filed by the judgment-debtor, therefore, delay on the part of the decree holder in depositing the amount under the first appellate court's order decree beyond 1 month as per the decree itself, would render the contract rescinded. Stop. Per contra, learned counsel for the respondents contends that the submissions advanced on behalf of the petitioners are contrary to the terms of the decree drawn by the first appellate court, operative portion whereof did not contain any direction for the decree holder to deposit the money, rather the direction was for the judgment debtor to accept the balance money after deducting rupees 8,000 which had been paid as advance money earlier and, therefore, the plea based upon the